SJC-13785, Commonwealth versus SW.
Okay, Attorney Martin Strout.
Good morning, Madam Chief Justice, and may it please the Court. Michaela Martin Strout on behalf of SW. In this case, SW was arrested for swatting at her adult niece, who was throwing out SW's belongings. She was released by the clerk magistrate and appeared in court a few days later for her arraignment, at which time the court ordered an inpatient competency evaluation. The court immediately revoked her bail and detained her in jail because there were no hospital beds available, and there would be no beds available for several weeks. The court ordered an inpatient competency evaluation because SW presented as mentally ill, including a fixed delusion that she was the Queen of England, and she was not voluntarily engaged in outpatient treatment in the community at the time of her arrest. This case presents numerous issues. I'd like to focus on the following three in the argument today. First, whether defendants awaiting competency evaluations may be detained without bail for that purpose. Second, whether a 15B evaluation may be ordered at all when a clinical opinion of competency is reached after the initial 15A evaluation. And third, whether a person exhibiting symptoms of mental illness and lack of voluntary treatment in the community is a legitimate legal basis upon which to hospitalize them pursuant to Section 15B. On the first issue, with respect to detention without bail, this is apparently uncontested. The Commonwealth does not dispute that there is no statutory or other authority for courts to be detaining folks without bail for the purpose of facilitating competency evaluations. We are asking the court to exercise its discretion to address this issue under its superintendent's authority because this is not just a single case that presents this issue. We've cited at least 4 other and 5, including this case, single justice opinions over just since October 2024, in which this precise issue of detaining people without bail for the purpose of competency evaluations has been raised. And so as Justice Stewart noted in the Arruda single justice opinion, if this is not just capable of repetition, it is being repeated across the Commonwealth. And so we would ask this court to reach that issue under its superintendent's authority. If there are no questions on the bail issue, I would move to the second issue, which is whether a 15B can be ordered after a clinical opinion is reached of competency after the initial 15A.
Factually, I don't see that the judge made a 15A determination here. You sort of, I read your brief and you leave out things of, what the doctor said or the expert said was, I think we need to have an inpatient review to determine her competency, right? She actually said that. She didn't say I determine her incompetent.
So, and I think perhaps some of the confusion is my use of the word determine in the briefing. And I think there is a distinction between the legal determination of competency, which is something that the court does at a 15D hearing after there is some clinical evaluation, either 15A, 15B, or both of the defendant's competency. Here, I believe the court clinician after the 15A evaluation did say that SW lacks, she opined in her testimony, SW lacks the skills for competency, that she was not aware of the charges against her or their possible consequences, and that it would be very difficult for her to communicate with her attorney about her case. And so, yes, eventually she then goes on to say, I think she should be hospitalized for evaluation and psychiatric treatment, which is to our third point about whether treatment is an appropriate purpose of a 15B evaluation or not. But I think there needs to be really this should be a two-pronged inquiry. First, there needs to be a determination that further evaluation is necessary at all on an inpatient or outpatient basis to determine this person's competency. And that comes both from the statutory language of 15B itself, which says that a 15B may be ordered only when necessary to determine competency or criminal responsibility, here competency. But AZ also talks about this too, that it needs to be necessary, and then it goes on to talk about the least restrictive alternative test. And so I think there needs to be this initial analysis or assessment or finding by the court that we actually cannot determine this person's competency after the 15A. And so there needs to be further evaluation.
Doesn't the statute contemplate this? Because the 15A, as you well know, is done by a clinician in court. It's a very brief proceeding. The judge is the person who has to make the determination, not the clinician.
Yes.
The judge hears from the clinician, and if the clinician says, I think there's something going on, I think she may not be competent or she's not competent, the judge says, all right, I need to make this determination. We need a fulsome evaluation for me to be, to make that decision myself. Isn't that what happens?
So I think...
You want to just short circuit it once the initial evaluation says not competent, it's over?
Not necessarily. So I think there's a wide range of things that can happen at the end of a 15A evaluation. I think a court clinician can and sometimes does, and I think the RD case, which comes next, this is a better example of this, where they don't say, I think this, my opinion is that this person lacks the skills for competency. They say, we need further evaluation to make that determination. And I think the facts here indicate that even though eventually there is this assessment of, well, we want a further evaluation, I think the facts indicate that really what that was about was getting SW treatment at the hospital for appearing as...
That was the tenor, I think it's fair to say, of the clinician's testimony.
Yes.
But the judge's decision was that the judge wanted a further evaluation under 15B. And that was the decision for the judge. And part of your brief sort of suggested that it wasn't open to the judge to make that ruling where the clinician had already said that she was incompetent. Are you standing by that if a clinician says she's not competent, the judge abuses her discretion if she orders a 15B?
Absolutely not. I think the critical fact here is that the judge credited the relevant testimony by the court clinician. So I absolutely concede, and the Commonwealth brings this up in their brief, and we talk about it in our reply. The legal determination of competency is a legal question for the judge to determine at a 15D hearing. The judge can absolutely disagree with the court clinician's opinion that I'm not sure that we can actually determine competency or that I can make that legal determination of competency after the 15A. And so I'm going to order the 15B. But I think on these facts, where the judge explicitly credits the testimony of the court clinician and specifically the testimony about the assessment of competency, that she, didn't understand the charges.
The judge didn't find the defendant incompetent. She just and I think there's a distinction between crediting the clinician's testimony and the judge herself being persuaded that this person is incompetent. Is there not?
Yes, there is. And I think that's...
where can you put your finger on the exact abuse of discretion here?
Yes. So, and I think this also gets to the next question of what the real reason for this hospitalization was, which we believe was this improper purpose of treatment as opposed to this assessment of competency. But the court, I believe, when discussing... because the court is clearly aware of the AZ opinion and does the analysis ostensibly of the least restrictive alternative. And so first the court talks about crediting Dr. Reese's testimony, her report, and then it says, this is on page 107 of the record, I further credit Dr. Reese's findings that SW is not fully aware of the charges or the consequences that she is currently facing. And then she goes on to the, outpatient evaluation is not viable due to the fact that she is currently suffering from being acutely mentally ill and is not aware of the charges or the consequences currently facing her. And so I think this crediting of the not fully aware of the charges or the consequences that is currently facing her, that really is the question of whether this person is competent or not. And the court could have chosen to say, I can't reach that determination. I'm not convinced yet, but it didn't. The court credits this testimony and then goes on to essentially commit her only because she may or may not be competent, which I don't think is the test that this court really articulated in Commonwealth v. AZ. If I could, I would like to move briefly to the third issue, which is the issue of whether someone being mentally ill or exhibiting symptoms of mental illness alone and the lack of voluntary treatment in the community is a basis upon which the court can order an inpatient evaluation. we would suggest that the answer to this question should be a resounding no for at least 3 reasons. The first is, if symptoms of mental illness alone can be used as the basis for an inpatient 15B, then AZ sort of collapses in on itself, because hospitalization can't be a tool of last resort, which is what this court articulated in AZ, if every time a criminal defendant presents as mentally ill and with competency concerns, an inpatient 15B can be ordered.
No, but wouldn't you agree that mental illness could be a factor to be considered? Because if the alternative is outpatient evaluation and the person is too mentally ill for the judge to conclude that outpatient evaluation is realistic, why can't the judge consider mental illness in that calculus?
So I think this gets to the question of, what does it actually mean for somebody to be able to comply with an outpatient evaluation? And the way that we articulated in our briefing is that this is really about ability to comply with court orders. And someone can be pretty acutely mentally ill and still be able to comply with a court order. And SW really demonstrates this herself, right? She is released on a Saturday with no attorney appointed yet, and she shows up, on personal recognizance in court for her arraignment on Monday, complying with, the court order for her to appear. And so I don't think that there's necessarily this inexorable logical conclusion that if someone's really mentally ill, they're never going to comply with an outpatient evaluation or...
No, but I took it you were arguing that mental illness could not be considered. It sounds to me like you're now saying, well, mental illness could be considered, but it can't be determinative.
So I think, I'm trying to think of a hypothetical where a symptom of mental illness would be indicative of someone's inability to comply with a court order to do an outpatient evaluation. And it's hard for me to think of that. I think it would have to be a really, really specific...
Well, if you think you're the Queen of England, isn't that concerning? I mean, aren't all of these relevant factors that the judge has to put together to make this determination? I see your point that there's a bias towards getting treatment for these people, and that may kick in here. That point, I think, is something I hadn't thought about in the past, but these are all relevant factors. The person's deeply mentally ill. If she thinks she's the Queen of England, she may have some trouble understanding the process here, and we need to really evaluate her carefully to do so. I just don't see this as an abuse of discretion. These are all relevant considerations.
So I think the Queen of England point is a really good one because, that's true, right? She believes she's the Queen of England, and yet she shows up to court, right? She comes in on Monday. She meets with the 15A evaluator and talks to her and completes the 15A evaluation. And so, despite the fact that there's this fixed delusion, that fixed delusion apparently, again, on these facts, doesn't demonstrate that she is unwilling or unable to comply with a court order.
The fact that she's not getting outpatient treatment for her mental illness indicates sort of that she tends to hit and do it and then run away from it. And doesn't that sound like a 15B type of issue? It's not conclusive, but it's a factor, right?
So I think that issue of whether or not somebody is voluntarily engaged in outpatient treatment. I think, the O'Connor case out of the United States Supreme Court 50 years ago says that we can't force people to be medicated simply because they're mentally ill. That is a constitutional choice that individuals have. And so holding it against somebody that they're not voluntarily engaged in treatment is very different from someone complying with a court order, right? Just because someone's not voluntarily engaged with something that they don't actually have to do legally.
But they've also potentially committed a crime, or at least they're accused of a crime, so they're not complying with the law. There's an issue about their ability to comply with the law here too. So it's
right, which is going to come up obviously in every case where there's a competency concern. I would also just note there are a lot of reasons, and this there aren't facts here to indicate why she stopped going to treatment. There was some indication that she had a psychiatrist previously at a local psychiatric facility and that psychiatrist left. And so I would also just note that there are a lot of reasons why folks don't have access to services in the community that aren't necessarily indicative of them not wanting to get treatment or not wanting to have access.
Can we go back to, because I don't want to, I know you have the other case as well, because we're also here to talk about the procedural posture of this case
Yes.
and how we got here. And one of the things that I'm concerned about is, assume for the sake of argument that we agree with you that there's no legal authority to hold somebody for purposes of just having the evaluation. And so there's an unlawful bail order of some sort that was just to preserve the evaluation, which can be appealed to the Superior Court if you contend that the 15A or the 15B order is unlawful. There's another vertical that you can go through the district court. So let's focus on that for a minute. Why isn't it more expedient for you to be able to go through both verticals versus filing a 211-3? And at least with the bail, you can get into the Superior Court faster than you can if a 211-3. And we've also said that there's a preference here that you go through the appellate division of the district court or the appellate division of the Boston Municipal Court. So can you address that issue here? Because that's a big deal. And I'm sure you were in the courtroom when Justice Gaziano said before, and I echo, I'm speaking as a single justice now.
Yes, I understand. So first, to address the bail review, this was a bail revocation. So that actually could not go to the Superior Court. That had to go directly to the SJC, and the Pires case is the case that holds that. And so that was properly in and of itself before the single justice. In terms of connecting the 15B, our position is that because the detention order was inappropriately intertwined with this hospitalization order, it didn't make a lot of sense for us to go to these two different jurisdictions, two different venues, to be able to get an answer on those two things, which had a lot, unfortunately, of factual overlap, even though they shouldn't have. The other issue here that I think is a broader issue is it is not possible to get timely relief from the appellate division in these types of cases with these really, really short commitment.
How do you know that? I mean, you did a really nice job when you talked about the ability for this to be repeated all the time, and I know that as a former BMC judge that it happens all the time. But how do you know this part, that you can't do this on an expedited, particularly if we had case law from us saying, hey, you guys can't come to 211-3 route. You've got to go to the appellate divisions of the community courts.
Yeah, and so I think this is where the difference between the Section 35 cases becomes really important, because Section 35 cases have their own set of uniform rules that mandate expedition of those cases. We don't have that in Section 15B cases, and under the rules, under Rule 2 of the appellate division rules, even, first of all, it's not a mandatory expedition. It's a discretionary expedition. And then even under Rule 8, which talks about the procedure for expediting these appeals through the appellate division, the timeline is that the case does not get transferred to the appellate division for 60 days, which for a 20-day commitment, right, that person will have been committed for 3 times over, right, before the case even gets to the appellate division and heard.
It's true, but these are all rules things that they have to pivot to if we say you can't do what you're asking us to do.
And so if the court is inclined to make this an adequate alternative, I think that the appropriate response is to issue a uniform set of rules, the same way that Section 35 cases have a uniform set of rules that specifically identifies that it needs to be done on this very expedited basis. We would suggest no more than 7 days, given how short these are. And then also that waiver of other things, and this comes up in Section 35 cases as well, waiver of other requirements like preparation of transcripts, which is going to take too long, versus just reviewing the FTR, and formal briefing versus just arguments by counsel. I see I'm well over time, so thank you.
Thank you. Attorney McGrath.
Good morning, Your Honors. Jocelyn McGrath for the Commonwealth.
I would like to just plunge in to your question, why isn't the Superior Court adequate for the purported bail order? And I would like to point out that there really was no explicit bail order. That, we call it a bail revocation. We're kind of call it purported, so-called, to as much as it purports to be. I think there is a bit of an ambiguity in that type of order because there is no, as every single justice found, there's no authority either in 58 or in 15B. So in a sense, it's kind of floating. I would suggest that any of the case law that has to do with bail revocation orders, types of appeal under 58, the Section 58 bail statute, probably do not apply because this is actually an order for a pretrial detention, generally, for the purpose of facilitating a 15B. In that case, we argue in our brief that you could say it's a matter of law that would arise in a competency hearing. But we think that the Superior Court is actually the best place for hearing these types of purported bail orders. It's swift.
We have to decide whether that's legal or not. And that's why we're here.
Right.
Because it keeps happening, despite, I think, 4 or 5 single justices here already saying that's shouldn't happen. So don't we need to definitively give you an answer about whether you can do that or not?
We would love for you to give us an answer.
So you really do want to be here.
I think our argument for it is that the single justices and anyone who goes to the law can easily find there's no explicit authority anywhere, but it is a pretrial detention. It's probably swifter to handle it locally, and it actually uses our court resources appropriately. An ordinary defense attorney can put up an appeal to the Superior Court. It actually requires more specialized knowledge to put up a 211-3, and it's a very simple analysis, shall we say. How do you feel about that?
How does that make you feel?
It makes me feel that it's a problem that's going to go away when we say, judges, you can't do this. So there's not going to be a question of appealing anything to the Superior Court because the practice of holding people because there's no bed or because there's no clinician in the courtroom that day and we got to hold you overnight to see the clinician tomorrow, you just can't do it. So there's going to be nothing to appeal.
I hope you're correct. I sincerely hope you're correct. We find that district courts.
It happens all the time.
Yes.
I know it happens all the time.
We
So
know
it's-
it happens
yeah.
all the time, and we all know it should not happen.
Yeah.
So, I think if we're gonna, of course, the issues are not intertwined to a degree that cannot be heard in 2 separate places. We think at least for the defendant's sake, we could handle it more quickly in the Superior Court if you find that that is appropriate.
How about the harder one, the institutionalization and whether that should be appealed to us or the district court, given timing issues?
If you would allow me, my brother ADA has, I would say, briefed this more thoroughly and has more thorough opinions based on his more thorough experience. I mean, we pointed it out in our brief that you have already decided that, yes, it takes too long, but that's just the nature of the beast. I don't know, I don't see how this is any different at this point, that you wouldn't reach the same conclusion, but perhaps you know something I don't know.
Could you please address the other argument that we've discussed today about a situation where here the judge credited testimony and expressly credited testimony that the defendant, to the effect that the defendant was not competent, and yet ordered an evaluation in circumstances where the clinician essentially said she's not competent and she needs treatment. There at some point there would be an abuse of discretion where a judge, it was very clear a defendant was not competent and a judge just ordered an inpatient 15B for the purpose of this person receiving treatment, as opposed to for the purposes of a competency evaluation. You're nodding, and I take it you agree with that. So can you say why this case is not that case?
That the abuse of discretion would be if it were so obvious that this person was not competent, they could just, on the finding, not the findings, on the opinions of the clinician, find in that moment after a 15A that the person was incompetent to stand trial. I am so uncomfortable with the idea of a court making that determination on really just one moment in time, one person's opinion in a 15-minute evaluation. It just seems to minimize the how thorough this assessment should be. I mean, there are so many things that could influence a person's capacity.
There are real consequences to that decision, including dismissal.
Right.
Exactly, and we need that threshold determination to be able to reach the on-ramp. We go to trial, or we go to a 16F, but, until we reach that determination, we have that, that problem with like sort of an indeterminate time period of being under prosecution. We're there. This is where if we have a bottleneck, we are already like kind of looking at, are people going to be held up by sort of a lack of a definitive, yes, we know this person is incompetent, and they're not likely to become competent. So I think we disagree with my sister that that the statute does not contemplate some, treatment possibility. And I think that's a separate issue from forced medication. I think when you have a defendant, there is an open question about whether this 16F off-ramp, which is for their protection, can be reached without a thorough assessment of whether they can be brought.
So you are arguing, as parts of your brief seem to suggest, that because of the existence of 15B, a judge who is confident that a defendant is incompetent can order a 15B evaluation because the judge wants the person to
get treatment? No, I'm sorry. I apologize because this person is a defendant. This is not a civil commitment. So this person remains a defendant, and those interests remain in our interest. Is we need clarity. Can we bring this person to trial, or are we looking at a 16F off-ramp? We don't actually care that much at this point, but we need that clarity. And that clarity, I don't think we can get from a 15A assessment.
So in terms of clarifying our cases or our standards, your sister raises two sort of subtle points, which is this judge, and she'll get treatment, right? And there's I haven't read all these law review articles they attach, but there's a bias because, clinicians like people to get treatment. They think that's a good thing. How do we weigh two factors? The fact that the judge says she'll benefit from treatment, should judges be saying that? One, and two, how do we deal with, well, I guess that's the first one. The second one is, how do you weigh the fact that they've refused to use outpatient services? Because that's different from not complying with court orders. I guess whether you agree with the analysis, she's raised 2 points that may benefit from some more discussion in our cases. But how when judges put that language in there, how do they deal with those two issues, or is it just too fact specific to really say anything?
I think I just have to start at the beginning. This is very subtle because judges should not be saying that, and yet we're sort of implying that maybe they're thinking that because of what we sort of acknowledge as bias against, mental illness, people with mental illnesses. I think the person is the defendant. And there are some things we require of defendants that we would not require of a civilian who has mental illness. And one of them is for their protection, and some of it is we need to be able to prosecute them. So I think that the analysis is different from just the civil commitment part of the statute. It's part of their protection, in essence, to make this determination clearly and as quickly as possible. So I think I think I already argued in that direction.
But
So.
I just think it's those two factors. The judge here relies on the fact, okay, she thinks she's the Queen of England, so she's got some serious disassociation problems. Secondly, she's not getting treatment. Your sister argues that's really problematic because she did show up to court. So that's obviously a factor that's important. The judge needs to articulate that, right?
Right, and
I'm concerned that she's not going to go to outpatient treatment. These are subtleties. I just don't know if we can say anything about them. But
I appreciate these subtleties, and I think I am not an expert. I'm a sort of an ordinary appellate attorney who's looking at the statute. I think the statute does contemplate needing a clear determination of someone's competency and whether they can be brought to competency. And I think because a judge has broad discretion in choosing the factors in which they make this determination, I don't see an abuse of discretion. I see it being, you need much more of a person who would not really be able to be competent or brought to competency. And I don't think that can be done in an initial evaluation. Does that help? I think I'm actually just at the end of my time. Thank you so much.